number that has to. Was this the motion?
Yes.
All right, yes. The B, there's something to be on page 1, 2, 5. Item number 7 on page.
All right, you're in agreement to number 7?
Yes, Judge.
Okay.
On the next page, for pleas and plea discussions, on, I believe that's item 9, great. Sorry about it.
No problem. All right, let's do this. So number 1, prior convictions. Before you all get into any of that, you'll have to approach.
Correct. We were just not agreeing to hearing, like a full on hearing to the extent that she was saying. But
Okay.
yes.
All right, so number 1, counsel, if you all approach. Number 2, there'll need to be a hearing if there's some issue where it's alleged that your client has made a statement. So we'll do that hearing outside the presence of the jury.
So that would be. I mean, we're talking about, I mean, not, it's in a, what she is covering in this is more than just the defendant's interview. It's statements made to witnesses, like it's too overreaching, Your Honor. Is why we
No,
didn't
the
agree
only
with it.
thing that the court is ordering is if there were statements made by her client that she's objecting to for whatever legal reason they may present, then statements made by her client will have to have a hearing outside the presence of the jury for that. Statements made by witnesses, you all will need to handle that on cross-examination.
You're talking about statements made by witnesses with regard to statements made by my client?
Is there allegation that the defendant made statements to,
Not in admitting, but just things that were said during the course of the crime that the witnesses were present for, like,
Oh,
he was
well-
saying this to the victim, stuff like that.
okay, well, that will need to be handled during cross-examination.
That's
but
what-
if-
yeah, that's why we were saying that it was, because some of it is, yeah.
All right, now, if it's statements made to authorities and not laypersons, then that's something that you'll need to approach and we'll have a hearing outside the presence of the jury on. All right, and then number 3, extraneous unadjudicated offenses.
We filed our forward so,
All right, you'll have to approach.
yeah.
And
Yeah.
my understanding is that we are still.
Yeah, just
required
approach.
to have a hearing for the court to make findings prior to the state one.
Yes, so just approach on that before any mention is elicited. All right, and it's the same thing with number 4. Y'all need to approach beforehand.
It's just to make clear, that's all I'm asking for. When I say hearings, I
mean-
mean, let's approach, and if we need to do something further, that's fine. But I just want to make clear that that's my understanding as well, is that we need to approach.
All right, and then with the identification of the accused,
That was to overreaching the work again, Judge, because we have a witness to say, yes, I know him, that's perfectly fine, but they were including that in their motion.
are you including that as well? Because I mean, for example, if it's his mother or his brother, I don't think we need to have a hearing outside the presence of the jury for them to say,
So these are all people that are related and know each other.
defense.
Judge, I don't think that we're gonna have any identification issues in this case.
All right,
I don't, you recall whether or not. I don't know if it was- When you show us or-
well, counsel, if there's an objection to a witness, because I'm sure the state will ask the question, do you recognize him in the courtroom?
No issue.
Okay.
What I don't recall specifically is if there was ever show ups or any identification procedures that involve law enforcement. I don't think that there were.
All right, if that turns out that that's the case, just approach it beforehand.
That's all.
All right, and then the post-arrest silence of the accused, that will be granted. Conversations of the accused with his attorney, you all have agreed on that one. Alias names of the defendant, I guess you all will need to approach on that because that depends on is he known by some other name by persons who are testifying? Plea discussions, you all have agreed to that. Expert witnesses and scientific evidence, if there's something that you want to have a hearing on with regards to science, just approach.
Judge, for the record, I'm not general. I just would ask for just a very brief hearing.
No problem.
I have to make a good record of that.
And then the reports or statements of state's witnesses. I'm assuming you all have those reports.
Yeah, no, it's like we couldn't have to refer to by paper, but I'm gonna take the reflection.
Okay,
And obviously we will be suggesting this either side could admit them or that would be.
The worry that I have, and I got some particular prosecutors, I really don't have a concern, but I have had circumstances in the past where sometimes prosecutor will ask somebody to read a portion of their report or refer to a portion of their report, and then they'll start dictating what that says.
Okay.
So that, I don't think that that's going to be a problem with either the prosecutors here today, that just want to make sure that that one's on.
okay.
And then Judge, for the state, we just filed a basic motion in limine that they approach if they want to get into any crimes or wrong acts for our victim or any of our. And that was also filed.
We are succeeding on them.
Okay.
We believe that we are in time to get into trial.
Oh,
We need to have a separate hearing for that.
I mean, that's, I don't need case law on that. If the issue is self-defense and if self-defense is raised, then the defense will be allowed to ask those questions, of course, in the proper format, but it's going to have to be raised. It can't just be asked about in the very beginning. So once, if there's enough evidence that's presented for a self-defense argument, then those questions can be asked. And I know both parties already know this. All right. So here is my question. So this is a murder, correct? And you all are proceeding on count 1, paragraphs A and B? Okay, we'll make sure you get a copy. And then, of course, you never know how the evidence is going to turn out. I don't know if anybody's filing an application, just in case there's a lesser included that's included. You just never know the way trials are going to twist and turn. Sure.
And one probably is a long shot that it'll impact anything that, so, as the court knows, my husband
Yes.
has some medical issues. So we have a doctor's appointment that he cannot go on his own because he's not.
Oh, just let me know.
So that's like 4:30.
Okay.
So if, and I'm not too far from here, so if we could maybe. break
Oh, here's the
early on
thing.
Thursday.
Just let me know and remind me of this and we'll make arrangements. It's not going to be a problem. Sure.
And if we go, I don't think it will go, but I am set to fly my folks, there's some stuff with them, not this Friday, but next Friday.
Okay.
I can.
All right.
And Your Honor, we have one, we're just saying that Dr. Friday is something. I think we have one of them.
Okay.
Anyway, so-
All right. All right. And so here's my question. If you don't have enough witnesses and if he's available by Zoom, would there be any objections to either party with him appearing by Zoom? Okay. Oh, I understand. Okay. All right. Is there anything else?
We can take care of this now, or we can take care of it later. The state's attorney provided me with additional photographs that I believe that she intends to introduce. There were 3.
Okay, I think we may need to take care of that later because the jury's been outside and I don't want the jury to be upset with anyone.
I think just pick it up on-
Oh, we can take this up when we have a break. All right, thank you. Sorry about that. We can take that up when we have a break.
Thank you, Judge.
All right, is there anything else?
Not that I can do that.
No, Judge.
All right, so we will bring, thank you. Okay. Oh, if you'll hand it to me, I'll give it to the clerk. So if he comes in, they can hand it to him. All right, thank you.
Matt, this one I think wanted to observe and just kind of see if you can share.
Oh, sure. There should be an extra chair somewhere. Is there an
There's
extra
one in
chair?
the office, there's, you can roll the one that's inside the office.
Yes.
All right, I'll do that.
Okay.
Judge, will you have 5 in the morning?
Yes.
Good luck, guys.
Thanks.
So much fun.
You have to give me spinning.
All right. All right. Is everyone ready?
Yep, yep.
Yes, Judge.
All right.
Ready. Number 1, this way. First row and the bottom.
All the way down.
Yeah, the first row, it has numbers on the
Oh,
feet.
gotcha.
Number 8. Second row is out.
Thank you so much. I appreciate it.
Fifteen, the bench. 22. You 22, next row. Number 30, next row. 37, next row. 44. 51. 7. Huh? You're 40. You would have a line 67. Pull out your numbers because you're gonna be using them.
Please be seated. Good afternoon, everyone.
Don't have to do it all solidly, do that again. Maybe they didn't hear me. Good afternoon, everyone. So I want to thank you all so much, and I appreciate your patience. But believe it or not, when you're called up and when you're in the hallway, we are not just twiddling our thumbs saying, hey, let's see how long their patience is. We're just going to let them sit out there and wait. There are other things that are going on. So the fact that we're starting now instead of 11:30, it is not either of these attorneys' fault. It's just that I have a docket every morning, and that docket usually has about 60 or so people on it. And so I have to reserve a jury, because if I don't reserve a jury, I will not have one for the afternoon. So you are in the 187th District Court. It's on the 4th floor. I am Judge Stephanie Boyd. So which courtroom are you in? What floor? And who's the judge? All right. I know what you're probably saying. Of course we know where we are. How else would we be here? But the reason why I have people repeat that is because sometimes we take breaks, and when we take breaks, all of you have to leave the courtroom together. And believe it or not, when people leave the courtroom, because unless you work here on a daily basis, people tend to get lost. We've had jurors before where we've been looking for them, and they've been trying to get on another jury panel. So I don't want you all to be trying to get on another jury panel. So if you look up and everybody's gone, you will know that you're on the 4th floor. You either remember the 187 District Court or remember the name Boyd. There's only one Boyd in the entire courthouse, and there's only one 187 District Court in all of Texas. So even if you were to go to Austin and want the 187 District Court, they'll say, that's not here, that's in Bexar County. Now, I'm going to allow the parties to introduce themselves to you for the state.
Hey guys, my name is Anna Ochoa Nelson.
Hey, y'all, I'm Allie Jackson.
And for the defense.
Hi, everybody. My name is Kathy Compton, and this is my co-counsel.
And your name? All right. And who is your client?
And our client, Angel, if you'll stand at, is Angel Gonzales.
All right. You may be seated. All right. Is there anyone here who recognizes any of those parties? And sometimes people will say at first they don't recognize somebody, but then once they start speaking to them or they learn something, then they end up recognizing them. So if throughout this process towards the end, you change your mind and you say, oh, I think I know this person, just let us know. Now, the charge in this case, well, before we get to the charge, to my left is the court reporter, Diana Guerrero. I always said if I was ever in a position to make somebody's job easier, I would do it. So the court reporter takes down everything that everyone is saying. So the reason why I'm talking this loudly is to make sure that she's able to hear. So you need to talk at this level also to make sure that she's able to hear. All right, if you'll wait outside for us, you're welcome. You're going to have people who come through the door because they don't read the sign on the door that says we're in a jury trial. You're going to have people who come from this side. They come from this side because their staff or maybe there's documents I need to sign. It has absolutely nothing to do with this trial. You're going to have people come through this door because they don't read the sign that says, please don't come through this door. We're in jury trial. And sometimes you will have students and other attorneys who come in because maybe they're going to have a trial in this court, or students who are trying to learn and see if this is the profession they want to be in. So they will come and observe. So with regards to the court reporter, make sure you keep your voice up and make sure you only speak one person at a time. So when either I or the state or the defense have questions for you and you want to respond, raise your card, because everyone please raise those expensive cards you have. And keep them raised until I ask you to lower them. All right. Everyone in the box here, please lower your card. Everyone on this first front row here, please lower your card. Now, the people who still have your card up, I'm going to ask you to do me a favor. Every juror and jury that we've had has failed at this. And every time I tell them I have faith in you, somebody never follows through. So I have faith in you. I'm hoping you follow through with this instruction. For all of you who have your cards remaining up, if you want to respond to a question, if you're able, please stand when you respond to that question. Will everyone be able to do that?
Yes.
All right, please don't disappoint me. I have strong faith that you'll be able to do it. All right, so now you may lower your card. Now, the charge in this case is murder. Now, when either of the parties speak to you, they're going to be speaking to you about hypotheticals. They are not allowed to talk to you or tell you what they think the facts are in this case. The only time they'll be able to tell you what they think the facts are in this case is if you're in this box and you're on the jury. Does everyone understand?
Yes.
So when they're talking to you, keep in mind, they're not talking about the accused who's sitting here. Does everyone understand?
Yes.
Now, everyone who has a felony criminal case, they're brought to court by way of an indictment. How many people, and I want you to practice raising your cards, how many people have ever had a traffic ticket? Don't be shy. All right, so I must say, this is the worst group of drivers that we have had in this court, because I ask that question all the time. Well, I've had a traffic ticket before. I had one in my lifetime, but then I'm only 21, so I have a ways to go. Okay, that shouldn't be that loud. So when I first got my very first traffic ticket, it was when the officers had the paper notebook and they write on it and they give you a copy and they keep the original. Now I think they do it computerized. So let's say the police pull you over and they say that you ran a red light and they take your name and everything and they give you a ticket. When they give you that ticket, by you accepting that ticket, you're not saying I ran a red light. That ticket is just telling you, hey, I pulled you over. I'm saying you ran a red light. If you want a jury trial, this is where you need to go. That's it. An indictment is the same thing. It's the means but whereby somebody is brought to court for trial. You cannot consider an indictment as evidence of guilt. It cannot be considered for anything. It's just a piece of paper that says, this is what we're charging you with, and this is where you need to be for trial. Does everyone understand? Is there anyone who will hold it against Mr. Gonzales because he's here under indictment?
No.
Now, the next thing I want to talk to you about is certain rights that anyone who's accused of a crime has. One is the right to remain silent. Has everyone heard of that before?
Yes.
Okay. What that means is you have the right not to testify. I've been a defense attorney. I've been a prosecutor. Sometimes when I would represent someone, I would give them advice. I would say, you don't need to testify. The state hasn't proven their case. Sometimes I would have a client who would be so nervous. I would say, it's not good for you to testify because we're just having a conversation and you're sweating. Sometimes people are just afraid of public speaking. Sometimes people sweat a lot and they think, oh my gosh, I just can't do it. But the key to that constitutional right is everyone who's charged, no matter what the offense, has a right to remain silent, which means they do not have to testify. Does everyone understand?
Yes.
Is there anyone, you cannot hold it against Mr. Gonzales, but is there anyone here who will hold it against Mr. Gonzales if he decides not to testify?
No.
Okay. Now, everyone is presumed to be innocent. So you can be charged with whatever, but when you come to court and you're in a courtroom, not like Mrs. Kravitz at Bewitched, but when you're in a courtroom, you are innocent until proven guilty. So what does that mean? That means if you were voting right now on whether Mr. Gonzales is guilty or not guilty, what should your vote be? Because you haven't heard anything, right? So when someone is presumed innocent, and that means they don't have to prove anything, that means that the state has the burden of proving their case. The defense does not have to do anything. When I was in law school, our professors, to really hit it home with us, they would say, you can sit over there, eat a sandwich. You can sit over there, do crossword puzzles. We've even had some cases that have gone up of appeal where attorneys have been asleep at defense counsel table. I have yet to see attorneys do crossword puzzles or go to sleep. But the reason why our professors did that, because they wanted it to be clear to us in our mind that the defense does not have to prove anything. The state has to prove their case, and they have to prove each element beyond a reasonable doubt. Does everyone understand? So if you are ever on a jury trial and you start thinking to yourself, if you're deliberating, well, why didn't the defense bring this evidence? Or why didn't the defense do this? You know that you are now shifting the burden and making the defense have to prove its case. And that burden never shifts. If someone is charged with a criminal offense, the state has to prove its case. And they have to prove that case beyond a reasonable doubt. Now, what is the definition of beyond a reasonable doubt? When I was in law school, you had to prove it. And you had to prove it, and you had to know it. And you had to know the definition, forwards and backwards. I knew the definition of proof beyond a reasonable doubt. I knew where to put my comma. I knew where to pause for dramatic effect. I knew where to put the exclamation point. I was so proud of myself when I had the first trial and I said the definition without stumbling over it. After that first trial, what happens? There is no longer a definition for proof beyond a reasonable doubt. They did away with the definition. So there is no definition for proof beyond a reasonable doubt. Does everyone understand?
Yeah.
So how do you explain it to people? Next door is a civil courthouse. It's the historic courthouse, the one with the green rooftop. Over there, they have civil cases. Their burden of proof, for example, if there's a fender bender and it's over, should this person pay money? Should they not pay money? Their burden is preponderance of the evidence. More likely than not, something happened. If you're ever in a criminal case and you're deliberating and in your mind, you're saying, well, I think more likely than not, this person did it. You know that you are not at the correct burden of proof. The other burden they have on that side is what's called clear and convincing evidence. Clear and convincing evidence is the amount of evidence that is needed in order to terminate someone's parental rights, where they say, you're a horrible parent. I think you'll be a danger to this child. So legally, we will no longer allow you to be this child's parents. That is the burden on the civil side. Clear and convincing evidence is a very high burden, but proof beyond a reasonable doubt is the highest burden that we have. Does everyone understand? Now, there are two phases to a criminal trial in Texas. First phase, people always like to call it the innocence phase, but really the correct term for it is, did the state prove their case? Did they not? Guilty or not guilty? That's phase one. If you deliberate and if you were to find someone not guilty, there is not a phase two. But if you were to find someone guilty, there is a phase two. And that phase two is what is called punishment. Our law requires that anyone who is going to a criminal trial must make an election or selection that if they were found guilty, who would determine punishment. And they must do that before jury selection. In this case, Mr. Gonzales has made the decision that if he were found guilty, then he is asking for the jury to assess punishment. Does everyone understand? Okay. Is there anyone who's going to hold it against him because he's elected or selected to go to the jury if he were found guilty? Now, I want to talk to you about ranges of punishment. In a murder case, the range of punishment is anywhere from 5 to 99 years or life in prison. That's a wide range. You got 5, 6, 7, 8, 9, 10, all the way up to 99 years, all the way up to life. Now, there's a reason why it's a wide range, because there may be different scenarios where you could see giving someone 5 years, 6 years, 7 years, all the way up for life. The key is whether or not you can listen to evidence if you were to find somebody guilty and take whatever facts you have and consider the full range of punishment. Sometimes people will have a knee-jerk reaction. They will say, I'll never give 5 years for murder on a case. But the key is, have you really thought about it? For example, let's say someone is married. They are high school sweethearts. They met when they were in elementary school. They always knew they were going to get married. As time passes, they have children, they have grandchildren. One of them gets a terminal illness. They're not going to recover from it. And they're constantly suffering. And it's getting to the point where they're having trouble breathing. And they're in constant pain. And they tell their spouse, you know, I just want to end it right now. Can you please help me? And that spouse saves up some tablets and gives them the tablets. They take them and they die. Does everyone follow my hypothetical? Okay. Now, that person is very distraught over it. The person really didn't want to do it, but they knew that the person that they loved was in great pain. Some may say that's assisted suicide, but it's murder here. Does everyone understand?
Yes.
Now, that person has no criminal history. Grandchildren probably come in and testify and say, no, they love their spouse and this is what we want to see happen. That may be a situation where you say, you know what? That person is guilty of murder, but we're going to give them 5 years. Does everyone understand? Then on the wider range, you may have somebody who maybe they've always been in trouble in their life. Their teacher always said, well, that person's going to grow up and end up killing somebody or something along those natures. Like that's the person who was walking down the street. They see a dog, they kick the dog just because. Or they see a child eating an ice cream cone and that's the person who knocks the ice cream cone out of the child's hand. The child cries, they laugh. And then you find out this about that person, their lifetime, what they've done. That may be somebody where you say, well, this person deserves life or this person deserves 99 years. And then you can also have situations where maybe someone's playing around with a gun. They don't know about gun safety and they end up killing their best friend. All of those are potentially murder charges. But does everyone see where maybe in each one of those instances, you would consider the lower range, the mid range, on the higher range? Does everyone understand? Yes. So in the case of murder, when you're thinking about different scenarios, is there anyone here who could not consider the full range of punishment? Yes. All right. And if you can't consider the full range of punishment, raise your card. All right. So 25, 32, 37, 43, 46, and 55. Thank you. Now, the next thing I want to talk to you about is the English language. I love the English language, and I love languages. In all my times in undergrad, grad school, and in law school, I ran across different classmates who are friends to this day. They speak so many languages. I can probably say hurry up in every language because that was all I could learn at the time. I never thought that I would be in Texas. So when I was in Louisiana and there was a chance for me to take a language, I already knew at 21 I was going to be retired, and I already knew where I was going to be living the rest of my life. So therefore, when my friend said, Stephanie, come take Spanish with me, I said, no, I'm taking French. So I did. And lo and behold, I'm here in Texas at the age of 21 and I'm not retired. So is there anyone here? English is not your first language. If it is not your first language, please raise your card. Don't be shy. All right, once I call out your number, please lower your card. 23, 27, 28, 45, and 49. All right, juror number 23. What is your first language? Don't disappoint me.
Oh, Hindi.
Don't disappoint me.
Yes, it's Hindi.
Oh, so how do you say hurry up in Hindi?
Jaldi karo.
All right, I'm going to try to remember that. All right, have you been able to understand everything?
Oh, yes.
All right, thank you.
You.
27.
Yes.
What is your first language?
Spanish.
All right. We all know how to say hurry up in Spanish. Have you been able to understand everything?
Yes.
All right, thank you. 28. And what is your first language?
Spanish.
Have you been able to understand everything?
Little bit.
All right. All right, thank you. Number 45. Yes, what is your first language?
Chinese.
Ah, this is the first time. So how do you say hurry up in Chinese? Say it again. Friday. All right, thank you. I'm going to add that. Have you been able to understand everything?
Yes, I.
All right, thank you. Number 49.
Hungarian.
Ah, this is new too. How do you say hurry up in Hungarian? Okay, I'm going to remember that. Have you been able to understand everything?
Yes.
All right, thank you. See, when I do that, the court reporter is always a little bit because she has to write that down and she can't write it down. So they know. All right. So next thing I want to talk to you about is travel arrangements. All right. Is there anyone here who has some type of travel arrangement that's coming up? You can't change the tickets. They're non-refundable. You can't put it in my name. Is there anybody who has a situation like that or any type of time constraints? If you do, raise your card now or forever hold your peace. All right. When I call your number, please lower your card. Number 9, 16, 19, 20, 45, 48, 41, 54, 72, and 70. All right, number 9, what's your time constraint?
Doctor's appointment next week.
And when you say next week, when is that?
Tuesday,
What time?
1:30.
All right, thank you. Number 16. See, this is what ends up happening. Okay, just 1 second. This is what ends up happening. I ask everybody if they have time constraints, and then everybody wants to see what will happen. Then everybody afterwards start raising their card. So in this box, all right, number 2, what's your time constraint?
I have doctor's appointment Wednesday and Thursday. Wednesday's at 10:30, Thursday is around the same time, I think it's 10. Next week.
Next week? Okay. All right, who else in the box? Number 10.
I have doctor's appointments this Wednesday,
All right, what time?
8 in the morning,
Oh, wow. Okay, thank you. That's early.
and then on through the day.
Okay, all right, thank you. Anyone else in the box? All right, number 16.
Travel arrangements, March 5th,
Oh, where are you going?
California.
What are you doing in California?
My dad died, sounds like.
Oh, I'm so sorry to hear about that. Number 19.
Travel arrangements, March 8th,
All right, where are you going?
Atlanta.
What are you doing in Atlanta?
It's for work. My husband's doing the Top Golf, so it's a little vacation and work as well.
Okay. Are you really going to spend time with him or are you going to just do your own thing?
Well, I work for the company as well, so it's a little of both.
Okay. Number 17.
I have a doctor's appointment. Well, I had eye surgery and I have a follow-up on this Friday, the 23rd at 12:30.
All right, thank you. Number 20.
Me and my husband are going out of town next Thursday,
And where are you going?
Austin.
All right, is this vacation?
Yes, it is. We're going to a concert in Austin Thursday, and then we're gonna spend the rest of the weekend there.
Who are you seeing in concert?
Disturbed.
Okay. And do you really want to go with your husband or not? Okay. Number 45.
I am a college professor. I teach on Tuesdays and Thursdays, and I teach 3 classes a day. So today I canceled all 3 my classes that impacts 60 students. So, if there's other schedules on Tuesday and Thursday, I will have a harder time to cancel classes for all day.
All right. And what do you teach?
I teach management.
All right. Are your students upset that their class got canceled?
Sorry?
Are your students upset that the class got canceled?
I don't know. They may decline, but for all the tuition they pay for a semester, more than like 2 times, or like that might be a problem.
All right. Thank you. Number 48.
Yes, Your Honor, I'm a solo practitioner attorney. I have court appearances in probate courts 2 and 3 on Friday the 23rd, Monday and Tuesday of next week.
All right. Thank you. Number 41.
Going out of town on February 29th.
Where are you going?
Vegas vacation.
But if you stay here, you may save money. All right. Thank you. Number 54.
Mine's still a little ways away, but March 22nd, travel plans, Washington, DC.
All right. Thank you. What are you doing in Washington?
Visiting my brother.
Okay. I already done 45. You want to give me some more information?
A travel plan on March 8th, 2000. Christina Hassan.
All right. Do you really want to go?
Yeah.
Okay. Number 56.
I have an appointment for my father this Thursday at 9 a.m.
Is that a doctor's appointment? Okay. Number 70.
I'm pretty much the only person that takes my daughter to and from work. Sometimes she works 9 to 3, some days are 2 to 8.
All right. Thank you for letting us know. 72.
I'm going out of town this weekend to go see my family.
And where's your family?
South Texas, in the valley.
And what date are you leaving?
This Friday.
All right. Thank you. Number 75.
I have 2 appointments next week on the 28th and the 29th.
And what are the appointments?
Here in San Antonio for a dental appointment and for my daughter.
All right. Thank you. Number 59.
Yes, I have a doctor's appointment tomorrow at 1 o'clock that I've been waiting for the last 2 months for. There'll be another 1 to 2 months if I have to cancel, and then Thursday I have an update for security background check for my job with the military.
All right. Thank you. Number 58. All right. Thank you. Anyone else? Number 33.
Appointments next week, Monday to.
Don't disappoint me. Don't fail me now.
I blow myself asleep. Monday and Tuesday, 26, I believe, post surgery on my foot, and Tuesday is eye appointment.
All right. Thank you. Anyone else? All right. Now, I'm going to tell you all 2 stories, and both of them are true. I understand that jury duty is an inconvenience, and I call it an inconvenience because really that's what it is. It's an inconvenience because you have to drive downtown, and normally people try to avoid downtown. United States has to be the only country I know of where people avoid downtown. And part of the problem is, 1, parking is expensive, and you're probably asking yourself, hey, I'm coming down here to do somebody else a favor by being on jury duty. Why do I have to pay for parking? And then when you get down here, you see the building, you think that's the building, but there's a one-way that tells you you can't turn left or you can't turn right. And you're thinking to yourself, but the building is right there. If I could just make this turn. So you have to circle around. and then pray that somebody's going to let you over because, again, you waited till too late to get over. Then you rush to the courthouse because they tell you to be here at 8 a.m. and then you wait. But when you think about it, your government only asks two things of you: jury duty and pay your taxes. And then with jury duty, they're not even asking you, the government is not even asking you to come once a month. They're not even asking you to come twice a month. I know there are some people here, this may be the first time you've been called up for jury duty. For some people, maybe this is your second time for jury duty. But usually you don't get that letter in the mail probably once every 3 years. So that's all your government is asking of you. And that's why I say it's an inconvenience. Let me explain to you what a sacrifice is. My uncle lived in a small town called Grand Cane, Louisiana. Extremely small. Went to school, super intelligent. All the teachers knew everybody, and the teachers kept passing him up to different grades because they were saying there's nothing else for him to learn in this grade. So they would move him up and move him up. Now, mind you, when his siblings came to school after him, they were a little bit upset by this because the teacher said, "We know your brother, we're expecting a lot of you." So he graduates from high school. And when he graduates, the Vietnam War breaks out. And he goes to my grandmother, and he's my grandmother's firstborn. And he tells her, they're already drafting everybody here. There's really nothing for me here. The only way to improve my lot in life is to sign up. And so my grandmother had to decide whether or not she would sign for her son to go off and fight in Vietnam. And when you think about it, back in that day, it's completely different than what you have now. Number one, nobody knew where Vietnam was. Number two, my grandmother had a 6th grade education. Smart as a whip, though, taught me how to read and write, and her children how to read and write. But she had to make the sacrifice to say, oh my gosh, I don't know what's going to happen to my son. And when you think about it, they had a television, one television, black and white, only got 3 stations. And I know some people here are too young to think about that. Like, what's only 3 stations? You only got ABC, NBC, and CBS. And really, it really boiled down to 2 stations because NBC, the weather had to be perfect. The sun had to be shining. You had to have that rabbit ears a certain way. Sometimes you had to put the tin foil on it to make it really work. And then television, the way you have it now, where it's 24/7, you can always turn something on. Television went off back in those days at a certain time. And you know when it was going off because they started playing the national anthem. And when they got really sophisticated, you would just see the flag waving with no sound. And then on NBC, it would just be white noise. My grandmother, her phone, when you picked up the phone to call somebody, you don't dial, you pick it up, the operator answers it. That's why you had that song out, Beechwood 75469. So you had 4 numbers to call. So when she signed for her son to go to Vietnam, they said, hey, if you send in a letter to him, you need to put Vietnam on it, put his name and put his number. That's it. So when he left, she didn't know till months later whether or not he arrived or not, because anybody here who's from a military family, you know that what the sergeant or lieutenant does when new people are coming in, they say, everybody write your mom a letter, write your dad a letter. And then slowly that makes its way there. So to me, that's what a sacrifice is. And unless the US government changed the law and starts drafting people, guess what? Jury duty is an inconvenience, and that is all your government is asking of you. So I know sometimes people are upset by different things, but if you think of it in real terms, this is just an inconvenience. The other thing I want to tell you about is my friend who decided to do civil law. On the civil side, no disrespect to civil attorneys, but on the criminal side, attorneys are always in court every day, a lot, going to trial a lot on the criminal side. I hadn't seen her in ages, and she called me and said she had jury duty. Could we have lunch? I'm like, of course we can. We have lunch. Lunch is great. It's like we haven't missed a beat from being in law school together. Then I asked her the important question. I asked her, how's jury selection going? And she's like, it's going fabulous. Now, since I've been a judge, how can it be going fabulous? You're not in court with me. And so she tells me, I'm not going to be selected. I said, what do you mean? She's like, it's like law school. I'm sitting on the back row, keeping my head down. Nobody's calling on me. And so I start laughing hysterically. And she's like, what's so funny? I said, I'm so excited. We're going to have lunch all week. So other than raising a card saying, please select me, the other way to end up on a jury, and this is just really any jury, is to be completely silent. And I know sometimes that people are wishing they were called up for jury duty on the civil side, because everybody has things in their background that may or may not make it hard for them to sit on a case. But remember this, when the state and defense, if they ask you questions about whether you can be fair, what they're really asking you is this: no matter what has happened in your life in the past that made you the human that you are today, the question is whether or not, if you were selected on this jury, could you listen to whatever evidence is presented to you and base whatever decision you come to on the evidence that you hear inside this courtroom? Is there anyone here who would be unable to do that? All right. Number 37. And 16. All right. Dinah, do you need a break yet or no? We can take a short break now. You want to? All right. So everyone, Diana takes down everything that everyone's saying. And even though you all have been here for this small amount of time, she's been on the record since 9 with us. So I'm going to give us a break and we're going to come back at 2:45. If anyone needs to go to the restroom, we can go off the record. Anyone needs to go to the restroom, wherever you see a stairwell, restrooms are on either side of that stairwell. So you can go all the way to the first floor, restrooms on the opposite side. Please leave your cards. All of you, when one leaves, everyone must leave. You can leave your personal items in your seat. We will be here. All right. Everyone, please rise for the jurors.
Right.
State defense, if y'all be comfortable. All right, everyone, please be seated. State, are you prepared to proceed?
Yes, Ron.
All right, you may begin.
Hey, everybody. There we go. We're a little bit awake. I know. It's almost 3 o'clock. One more time, my name is Anna Ochoa Nelson, and I represent the state of Texas, Bexar County, along with my partner for this case, Allie Jackson. And there's one person I'd be so sad to not introduce you to. We have another attorney in the group. His name is Zach Dunn. You're going to see him come in and out of the courtroom during the course of trial if you're lucky enough to come and spend a few days here with me and Allie and defense counsel, right? And judge, of course. So we're here today to talk about a few things. I'm going to ask you some questions sometimes. And I know public speaking is one of the greatest fears that exists for a lot of people. I clearly don't have it, but believe it or not, I used to. But I want you to remember a judge's rule, because if you don't, Diana's going to throw something at the back of my head. We need to speak loudly if we're here or in the front row. And if we're beyond that, I ask that you please stand and raise your cards, okay? So we're going to jump right in. We are here today to talk about murder. State of Texas versus Angel Gonzales. And as Judge said, we're just here to be fair and impartial. What does it mean to be fair and impartial? Well, it means that we start with the presumption of innocence. As the defendant sits right there, he is innocent, right? All we're asking you to do as a juror on this case, if you were to get selected, is to make me and Allie and Zach do our jobs. He is innocent until he is proven guilty. It is the state of Texas's job to provide testimony, evidence, to hopefully get you to that point, but you can't make that decision until the very end. You make the decision based only on the evidence that gets presented to you. We're looking for 12 people who can do that, right? So every case the state of Texas presents to you, we have to be able to prove each and every element of the offense beyond a reasonable doubt. There is no definition of beyond a reasonable doubt. I can't tell you what it is. It's different for each and every person in this room. It is whatever you deem it to be. But we know what it's not. It is not all doubt. It's not 100% certain, and it's not beyond a shadow of a doubt. Okay? Now, during the course of the trial, if you're selected, we would ask you to look at each and every element of the offense and ask yourself a few questions if you get there. Do I have a doubt? Is it reasonable? And does it go to an element of the offense? Thank you. Okay, so let's put it into play. Let's apply it. Back when I was pregnant a couple years ago with my youngest, I had the biggest craving for these sugar frosted sprinkled cookies. I could not get enough of them. The only problem was my oldest had a craving for them too. Okay. So I go to HEB, we come home with this carton of cookies, and you'd be like, Mommy, can I please have a cookie? And I tell him, no, son, you gotta wait until after dinner. You have a good dinner, you can have a cookie. We'll have one together. So lo and behold, I'm putting away all the groceries, taking care of everything. I go to my room real quick to go to the bathroom. I come back out and I see that the dining room chair has been pushed up to the counter in the kitchen. I see the box of cookies open. I see little pink frosting crumbs, sprinkles, cookie crumbs all over the counter, a little trail of them over to the living room. and I see my son with paint frosting all over his face. And I say, buddy, did you go take a cookie? And at the time, he was about 2.5, 3 years old. He said, no, mommy, Louie did it. Our dog Louie, that's him right there. And Louie just sitting there next to him like, what did I do wrong? Right? Now, is it reasonable for me to believe in that moment that Louie is the one that got into the cookies? Juror number 21? Why not?
Because your son had all over his face.
He had it all over his face, sure.
The dog doesn't look like he had it.
The dog didn't look like he had me. Now, what if instead of my son having pink frosting all over his face, maybe like Louie had some pink frosting on his mouth? What if he had sprinkles on his paw? Would that be reasonable then to believe that Louie didn't?
Yes.
Yeah. Well, lucky enough for me, when my son was about 2 or 3 years old, he thought that he could just tell me he lied. Okay, so I would say, Bud, is that a truth or a lie? And he would look at me with the biggest smile on his face and he would say, it's a lie. Now we move on. So eventually when I press him, he'd tell me, oh, mommy, that was a lie. It wasn't reasonable under those circumstances for me to believe that the dog got into the cookies and ate the cookie, right? Based on the evidence that was before me, I was able to determine that my son was the cookie bandit, right? Okay, so that's what we're talking about here. We don't really have to overthink these things as we go through. The concepts here in play are actually can be very, very simple. The key is to not overthink too many of the things here. Okay. So we're here for murder. We talked about that. Murder can actually be charged 3 ways. Murder with intent to kill, murder with intent to cause serious bodily injury, and felony murder. In this case, only 1 and 2 are at play. Okay, so let's talk about serious bodily injury and what that is. Bodily injury, or serious bodily injury, excuse me, is bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or the protracted loss or impairment of the function of any bodily member or organ. Okay, so that's in that serious bodily injury function. That's the definition of serious bodily injury. What about deadly weapon? Okay, there's the obvious, right? Firearm, probably that comes to most people's minds, a gun. Can anybody think of any other deadly weapons? Knife, sure. Anything else?
Your foot.
Sorry, juror number 15. A vehicle, sure, yeah. Well, see, the next thing underneath that is anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing serious bodily injury or death. All that really means is anything can be a deadly weapon depending on how you use it, okay? There can be all different kinds of deadly weapons. But the ones that come to mind, obviously gun, you all said knife, car. There are some ones that are pretty simple and straightforward. Okay, so the murder elements at play in the first part of this are on or about October 3rd, 2021 in Bexar County, Texas. The defendant intentionally or knowingly caused the death of Isaac Aguilar by cutting or stabbing him with a deadly weapon, a knife in that case, okay? Does everybody here agree that they're gonna hold me to my job, right? They're gonna be fair and impartial. They're gonna make me do my job and prove each and every element of the offense beyond a reasonable doubt. Can everybody agree that they're gonna make me do my job? Yes. All right, thank you. Technical difficulties. Okay. The next way that we have in play here are on or about the 3rd day of October 2021 in Bexar County, Texas. The defendant, with the intent to cause Isaac Aguilar serious bodily injury, intentionally or knowingly committed an act clearly dangerous to human life, which caused the death of Isaac Aguilar by cutting or stabbing him with a deadly weapon, a knife. Can everybody once again agree that they would hold me to my burden beyond a reasonable doubt, that I would have to prove each and every element of the offense beyond a reasonable doubt.
Yeah.
Yes, great, thank you. And thank you for bearing with our technical difficulties. All right. So let's talk about self-defense. Self-defense is when a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against another's use or attempted use of unlawful force. Now, in law school, we spend a lot of time talking about what is reasonable and the reasonable man or woman or person, probably now. And so we hear a lot about reasonable. Reasonable is all over the place when it comes to the law. Let's talk about what a reasonable belief is. A reasonable belief is a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant, not necessarily from the defendant's standpoint. We're talking about an ordinary and prudent person's mindset at the time that those events are happening, okay? So that's with regard to self-defense. We're going to take it a little further and talk about self-defense with deadly force, okay? So when and to the degree the actor reasonably believes that deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. Does anybody want to talk about what they think that means? What about you, juror number 7? What does immediately mean to you?
Protect yourself.
To protect yourself. What about that word immediately?
If something happens, you have to immediately react.
Sure. Would that be fast or slow or something that happened a long time before or a long time after? What are you reacting to, I guess, when you're allowed to use deadly force?
You're reacting to the threat in front of you.
The threat in front of you. That's actually a great way to put it. You're reacting to what is immediately apparent to you and what a reasonable and ordinary and prudent person would do in the same situation, right? That's a great answer. Thank you, number 7. Okay. So if we break it down a little bit more, what does it mean? 2 fists right here. Okay. You can respond against unlawful force with force. Okay. Boom. You can bring a fist to the fist fight, right? Everybody agrees with that. You can bring a fist to the fist fight. Punch for a punch. What about this? A gun to a gunfight? You can respond against unlawful deadly force with deadly force. Is there anybody who doesn't agree that you're justified legally in bringing a gun to the gunfight? Sure, because that is what's immediately necessary right in front of you at the time, right? What about this?
Your Honor, can we approach?
Yes. I'm going to make a ruling. Ladies and gentlemen, the law is to come from the court. So I will tell you what the law is. Does everyone understand? All right, you may proceed.
Sure. Thank you, Your Honor. You cannot respond against non-deadly force with deadly force. And Judge is absolutely right. All the law that you're going to have to follow in this courtroom would come from the bench, would come from Judge Ford, right? So kind of taking self-defense a little bit further, it does not apply if a defendant provoked the difficulty or if the defendant was at the time of the use of the deadly force engaged in a criminal activity other than a Class C misdemeanor. Okay, Class C misdemeanors, traffic tickets are probably what we most commonly think of when we think of Class C misdemeanors. Okay. Let's talk about what are not valid reasons to use self-defense. Okay. Just being angry, okay? That's not a valid reason. Because the victim had it coming. Or because the victim in a case just did something to you in the past. Or just generally kind of being a little scared of the victim. Not a valid reason. Well, the victim was a bad guy, also not a valid reason to use self-defense. And because the victim said something mean. Words alone don't give anyone the right to become a victim, okay? By claiming self-defense, the defendant is admitting to the conduct. He's admitting, yes, I intended to kill or cause serious bodily injury, but I was legally justified in doing so because I acted in self-defense. That's what happens when you claim self-defense. Yes, I did it, but I was justified. All right. Does anybody here watch CSI, or was it CSI fans back when it was in its heyday? Can you turn your card around? Juror number 7043. Yeah, there's cards going up all over here. People still watch CSI. They at least know what it is. Show me your cards if you know what CSI is. All right, there we go. Unfortunately, the way things work in here, the evidence that actually comes into play, it's not as cool as what's in CSI. It's really not. Remember my friend Zach Dunn up here, the other attorney in the room? He's sitting in a very important spot. This is the witness stand, okay? And in fact, most of the evidence that gets presented in the courtrooms comes from, well, all of the evidence that gets presented in the courtroom comes from the witness stand. Testimony is evidence, okay? It's not just the cool weapon or the DNA analysis or all that. It almost always, sometimes all we have is just that testimonial evidence, and that counts. That's enough, all right? So we are having a hard time today. All right. Does anybody know who this is? Juror number 10? Who is that?
Can't remember his name.
Juror number 12?
Christopher Maloney.
Christopher Maloney, that's his real name. What's his name in the show? Do you remember? Agent Stabler. Okay, I wish all of my witnesses were like Agent Stabler. Professional witness, cop, detective. That would be great if all of my witnesses were professional witnesses like that. But you know what? They're just not. They're regular, everyday people sometimes, just like you guys, okay? They come in, they tell what they saw or whatever piece of evidence they have for the case. They just come in and they talk about it. Regular, everyday people who don't have to do this all the time and don't like to speak in public and don't really want to come down here or whatever the reason may be, okay? What are some reasons that people might not want to come in and testify? Number 73, what's a reason somebody might not want to come in and testify up there where Mr. Dunn's sitting? Retaliation. Sure, retaliation. Any other reasons? Juror number 18?
They're a loved one?
I'm sorry?
They're a loved one?
They're a loved one? Sure, yeah, it can be complicated. There can be conflicting feelings. What about somebody over here? Juror number 5, what's a reason somebody might not want to come in to testify? Scared. Scared, right? There's a lot of different reasons. Maybe somebody doesn't want to. They're not a professional who gets up there and, you know, they don't have a police report. They're not trained in this, right? There can be a million different reasons, and that's okay. Talk about this. What does a murderer look like? Right? I feel like there's some preconceived notions here. I see juror number, what's your number? Juror number 8. You can see my next slide from here, can't you? No, you can't? Okay, well, does anybody know who this is? Charles Manson, right? Okay. He looks pretty crazy. He looks a little scary. I'd be scared if Charles Manson was sitting here in this courtroom. But not all murderers, certainly not all defendants look like that. Who's this? This clean cut, youngish man, juror number 8. Ted Bundy. He's a murderer too, big time. All right, so there are a lot of different preconceived notions that we all have about certain things, but it's not about what a person looks like. Okay, you all came in here and you promised me one thing, and it was that you would make me do my job, right? You're going to hold me to my burden. You're going to make me prove each and every element of the offense beyond a reasonable doubt. That's my job. That's not theirs. Okay. Judge, how much time do I have?
24 minutes and 58 seconds.
Thank you. Okay. Now, this case is going to the jury for punishment if there is a finding of guilt, okay? There are a few different reasons or combinations of reasons that people have about punishment, what the purpose of punishment is. Some of the ones that we hear quite a bit are that punishment is for the purpose of rehabilitation. The example there, everybody messes up and they can change. Another one is making amends. Punishment is to help a victim's family recover. Some people think that deterrence is the primary purpose of punishment, preventing this from happening again. And sometimes people think the purpose of punishment is punishment, and that's just fine. If you do the crime, you do the time. What I see, the more and more that I do this, is that some of those reasons, they start to overlap, or there can be multiple different reasons for punishment. Judge did a really good job of going over punishment with you before I got up and I started talking. She gave examples of maybe why you might consider the low end of punishment, which is 5 years for murder in the state of Texas. And she gave some examples of why you might go higher. And everybody in here, except for a few of you, I already got your numbers, promised that they could consider that full range of punishment. Okay. Fun fact regarding punishment: if the state, being me and Allie, are able to prove to you beyond a reasonable doubt that somebody has a prior felony prison sentence, the range of punishment can be elevated from 5 years up to 15 years. The ceiling stays the same, it's still 99, but the floor rises. Is everybody okay with that? If we prove to you beyond a reasonable doubt somebody might have a prior conviction, is everybody okay with that minimum floor of 15 years?
No.
Who says no? 37, 46, 43, 56, 4, 19, 25, 60, 59, and 58. Cards down if I called your number. Did I get everybody? Did anybody not have their card read? Okay. Now, Miss Jackson's going to get up in just a minute and ask you a couple of questions of her own. But before I sit down, I want to know if there's anybody here who has something just on the inside that they're saying, man, if I don't tell the state or defense about this, it's going to eat me up on the inside. I feel like they need to know this about me before we continue any further with jury selection. Juror number 32.
I don't know if I can go through this. My brother was murdered.
Okay. How long ago was that?
It's been 20 years. But
20 years.
It brings me a lot of memories.
Okay. Thank you for sharing that with me. Juror number 57. Okay. He's a nice guy, right? Juror number 66.
I'm sorry, I just had a question. Are we saying on the right, it's any prior prison sentence or for a similar?
Any prior felony conviction, first through third degree felony. Okay. And we have to prove that to you beyond a reasonable doubt. Did I answer your question?
Yes.
Juror number 16.
I'm an ER doctor, so I have to treat these patients all the time and tell their families they're dead.
Okay.
So just makes me emotional.
Sure. Thank you for sharing that with me. Okay, I'm gonna hand the floor over to Ms. Jackson.
Alrighty, y'all. I'm not gonna take up too much time. There's just a few things I'm gonna go over, but the first thing is more of a housekeeping thing. I always like to tell people is that if you wind up in the box, you're gonna notice that you don't get to be on your cell phone. But you may notice me and Anna, or sometimes even defense on our cell phones. Please don't think we're being rude. This isn't like Law and Order where this is the only thing that we all get to concentrate on until this trial's done. Sometimes we're wrangling witnesses, sometimes we're conferring with other attorneys, and sometimes defense has to confer with other people. So please don't judge us or think we're being rude if you see us messing with our cell phones. I promise we're not like scrolling on Insta. So there's just a few people that I have to ask some questions to, and I'm going to do this quickly. So juror number 7, have you served on a criminal jury before?
It was juvenile jury.
Juvenile jury? Okay, what kind of case was it?
It's been 15, 20 years, I don't remember.
Okay, do you remember if you guys went to judge or jury for punishment back then?
I don't remember.
Okay, no problem. Juror number 10, you also served on a criminal jury, correct?
Yes.
What kind of case, if you recall?
It was, had to do with, proving, the person, had mental illness.
Okay, so it was a mental health trial.
Right.
Okay, how long ago was that?
Probably 30 years.
Okay, was it here?
No.
Okay. All right, next I'm gonna jump all the way to juror number 33. You also served on a criminal jury.
Yes, it was here in town. It was a hit and run vehicle, child was killed, and the charge was leaving the scene of the accident. It was a jury, and it went to the first and the second phase.
Okay, thank you so much. He knew exactly where I was going with that, y'all. Okay, juror number 40. You also served on a criminal jury, correct?
Yes, about 15 years ago.
Okay, was it here in Beck County?
No, it's Harris County.
Okay, do you remember what kind of case?
It's like an undercover drug.
Operation, okay. Do you know if you guys went to judge or jury for punishment?
Jury.
Jury, okay. Thank you so much. And then juror number 42. Same thing?
So I served on, it was a child sex abuse case.
Was that here in town?
It was.
How long ago?
3 years ago, maybe.
Okay. Did you know if you went to the judge or the jury for punishment?
Well, we found him not guilty.
Okay, didn't make it that far. There we go. Okay, thank you. And then juror number 46. Have you been on a jury before?
I went through this process, but that was it.
Okay, you didn't make it on. Okay, wanted to double check. Thank you so much. And then juror number 49. Were you also on a criminal jury?
Yes.
What kind? Do you remember?
It was underage, sexual case.
Okay. Do you guys know, do you remember if you went to the judge or the jury for punishment?
Into the judge.
To the judge?
Not have the person.
Okay, thank you so much. And then juror number 52. Same question. Were you on a criminal jury? No. Okay. Sorry. Sometimes we have you guys marked on here and then you're actually not. Juror number 54. This is actually a different question. You work in a law firm, correct?
Yes.
What kind of law do you guys practice?
Real estate and tax.
Okay. Just wanted to double check. Let's see. We have a bunch of former jurors on here, guys. Juror number 64.
Right here.
And what kind of jury were you on?
That was about 20 years ago
Okay.
in El Paso, Texas.
Okay, so very, very long, so a while ago. I want to say long ago, but 20 years really isn't that long these days. Do you remember if you guys went to judge a jury for punishment?
They settled before we.
Okay, let out. And then juror number 73. What kind of case were you on?
I was a grand juror.
Okay, was it here in town?
No, it was in Travis County.
Okay, so you don't recognize me or Anna, because
No.
we, okay, double checking. How long did that term last?
3 months.
Okay, thank you so much. Now, let's say, yeah, be glad you guys aren't vendors. It's a very different process. So that's really all I have. Now, Anna already had you guys say, if there's anything, you wanted to share, but some of you may be sitting there going, there's something I want to share, but I don't want to share with my 75 new best friends. And I would really rather bring this up to the attorneys and judge. If any of you have something that you really think will affect your ability to be on this case that you don't want to share with everyone, please just raise your cards and we can talk to you guys later. Juror number 55. All right, we're gonna start in front. Now, as I say your ones, I'll call you, or you can raise, lower them. Number 4, 8, 9, 19, 26, 30, 31, 36, 37, 55, and 75. And juror number 10. Alrighty, speak now, forever hold your peace. 54. Alrighty, guys, I'm gonna hand this on over to Ms. Compton. Yeah. Do you have? I just put it over there. Okay. Yeah. Oh, whoops, I already moved it. I think it's easier. And then I just plugged it in.
Everyone, technology can be very fickle.
Welcome to the future.
Yeah.
Okay, try it out, Kathy.
And a lot of times we have trouble with the equipment here in the 187.
There you go.
Okay. All right, defense, are you prepared to proceed?
Now, I'm about as prepared as I hope to be.
Okay. All right, you may proceed.
Good afternoon, everybody. I'm going to apologize because I have reached that age where I have to put my glasses on to look at my papers and take my glasses off to look at you. So I know that's distracting, and I'll just apologize in advance. So the judge talked a little bit about just jury service in general, and I want to let you guys know that I am absolutely envious of the 12 of you who end up on this jury. And I'll tell you why. Because I will probably never be selected to serve on a jury. And that is something that a lot of people try to think of ways to get out of, but it is something that is so important. Now, why will I not ever get selected to serve on a jury? Well, I was a prosecutor for about 15 years, and I was a chief of family justice in another county, and I did all kinds of trials as a prosecutor. I've been a defense attorney for almost that long as well. I'm a cop's kid. My dad was a police officer, moved up to be a detective, and my godfather, my dad's best friend, was killed in the line of duty when I was a kid. And that was about as close as I've ever come to losing my own dad without losing my dad. And that framed all the things that happened to me and many of the things that I decided to do as I grew up. My brother was in the military. My brother was an Army Ranger. And so for those of you in the military, that means, as you know, my brother was crazy. But my brother he is a disabled veteran. He came back, he had a really, really hard time. And my brother ended up going to prison. So even as a prosecutor, I never for a minute forgot a couple of things. Everybody belongs to somebody. Everybody has a family that loves them, people who grieve for them, for the things that go wrong in their lives, people who celebrate the things that go right. So being part of this process is probably one of the most important things you will ever do for other human beings on this planet. It is an honor and it is a privilege. And I envy the 12 of you who end up here with this important job of making sure that everyone's rights are respected. Because if Angel's rights aren't respected, then your rights may not be respected, or your daughter's rights, or your son's rights. And that's why it matters. And no matter which side of the courtroom any of us are on today, we all want a fair trial. And if you don't answer the questions, or if you hold things back, or if you aren't completely honest as you took that oath to be, nothing works. Nothing works right if one little piece of our puzzle is corrupted. And the jury, you guys, the 12 of you who serve, you are the absolute heart and soul of what happens in this courtroom. The judge is important. Don't make any mistake about that. The law comes from her. She will guide us, but you are the engine that runs justice. And so please, even if you have to approach, if there's something you need to talk about, if there's some reason why you cannot be the most fair juror for this kind of trial, you gotta let us know. And you gotta let us know before we get started. So can everybody agree that you are going to be absolutely 100% honest, and that if you need to approach or if you need to tell us something uncomfortable, you'll tell us? Can we all agree to that?
Yes.
Thank you so much. So a lot of people, when I first went from being a prosecutor to being a defense attorney, they asked me, how can you do that? Doesn't it make you uncomfortable? How can you defend people who do this or people who do that. And I always kind of think like, well, how can I do it? I was so proud to be a prosecutor and to represent the state of Texas. And I am just as proud to represent Angel. Because my job is just what I told you. I got to do my job to make sure that his rights are respected. And the most important right that he has as he sits here in front of you all today is he has a right for you to look at him wherever you're sitting in this courtroom and to look at him and to presume that he is absolutely innocent. How many of you, and tell the truth, raise your card if you did this. How many of you, when you walked in and saw him standing here, how many of you looked at him and wondered, I wonder what he did? Raise your cards, it's okay. You see why that presumption of innocence is so important? Because that's not fair, is it? Number two, do you think that that was a fair question?
Oh, you mean your question?
Do you think it was fair for you to ask that to yourself?
No.
I wonder what he did.
No.
Does it make you uncomfortable that you had that thought?
Yeah.
And why?
It's human nature. I guess it's for us to think that about another human, but.
Yeah. And number three, let me ask you, do you consider yourself to be a person who judges people harshly or fairly?
Fairly.
Okay, but you raised your card saying, I wonder what he did, right?
Yes, ma'am, because we're here for a reason. That's the reason we're here.
Right, so you say you're here for a reason.
Yes,
So
ma'am.
to me, that sounds like you're already presuming that he did something wrong. Do you feel that way? If you do, and it's okay.
No, like we're here for a fair trial, so it's gonna get a fair trial, but we are here for a reason.
Yeah. Is there anyone who thinks that as Angel sits here today, that he must have done something wrong or else he wouldn't be here in this trial? That you can't set aside that presumption of innocence and make the state prove their case? And it's okay if you feel that way, but you've got to let us know. I see number 37. I'm going to start over here. Number 1. So let me ask you, like, can you explain how you feel?
Well, he's been accused of something and he's in a court of law.
Okay. Has anyone ever accused you of doing something you didn't do?
Sure.
That you knew about? And did the accusation mean that you did it?
No.
Okay. Is there anybody here who thinks that an accusation is in and of itself is evidence enough for you? No, right? I mean, it doesn't work that way. Even common sense, right? So the questions that I'm asking you, and I want everybody to think about it, and for those of you over on this side of the room, it's not that you're not important, but generally the way that this process works, it's kind of a process of elimination, and each side gets to make what's called strikes. And so you're this is sort of the splash zone over here. These people are a little bit more likely to be on the jury, and not that you can take a nap or anything, because in these types of cases, we sometimes run through quite a few jurors, but the people over here, you're probably less likely to be on the jury than some of the people over here in what I call the splash zone. So if I'm focusing my questions over here, please don't feel like I'm neglecting you, but that's why I'm focusing over here. So I guess what it boils down to is this. You've got to ask yourself, can I be on the jury and come in with a blank slate? And everybody, we all come from different experiences and we all have we make different judgments. There's nothing wrong with that. Like, I have all kinds of prejudices. Like, I'm getting over it, but as I get older and I travel more, but I used to not be a fan of anybody that wore Speedos, like the verbatim. I hated seeing them, you know? But, you know, now it doesn't bother me as much. But that kind of judgment, who cares? Like, I can be judgy. You know, there's all kinds of ways that we judge people. But there are certain things that you can't bring to a courtroom. And you can't look at Angel and go, you know what? I don't like his hair. Or, you know what? He's got his shirt buttoned up in a way I don't like. Or he looks thuggy to me. Or he looks brown. Can't do that either. And a sad fact is, there are counties, some of them not too far from here, where I have had people who come up one at a time. They usually don't volunteer it in front of everybody, but I have had people come up and say, I can't be fair because I don't like Mexican people. I don't like Mexican American people. I don't like Black people. I have had it happen. So that's why I'm bringing it up. So it's okay. You can feel however you want. Nobody's telling you what to think. But if you have respect for the system, respect for yourself, and respect for the rights of everybody else, you've got to be honest. And if you believe something like that, then you better have at least a little bit of bravery enough to come out and say it out loud, at least to the judge. Right not to testify, I think that everybody understands that, and I think that the judge and my colleagues have gone over that enough where everybody understands. Whether he testifies or not, you cannot use that as evidence in the trial. You can't say, oh, I wish that I had.
Oh, something with crazy. All right, I think it's fixed now.
You can't say to yourself, oh, I feel like I should start singing.
Are you ready?
Yes, I'm ready.
Okay, you're good.
Thank you. You
I know
can't
what's going
say to yourself, well, I want to hear, you know, I wish I'd heard his side of the story, or maybe I think somebody who's not willing to get up on the stand and tell their side of the story, well, probably guilty. Because it's human nature. That's one of those things again. Human nature to be judgy. People can be kind of like that. It's also human nature to want to hear both sides. Would everybody agree to that?
Yes.
Okay, well, guess what? The Constitution of the United States, and we also have a Texas Constitution, and it guarantees, and it's a built-in already his side of the story. You brought it in here with you. What is his side? Say it, anybody. He's innocent. He didn't do it. You have to presume he did nothing. That's his side of the story. And guess what? The law requires you to bring it in here and bring it to this jury box and sit here with it until they can pry it out of your hands. That's the way it works. The judge went through a great explanation of all the different levels of proof and what is beyond a reasonable doubt. And she's right. I am probably a little bit older than the judge, and I do remember that when we did have a great explanation and a definition of it. And the legislature decided that, you know what, it's common sense and people know what that means. So it's what it means to you. But let me give you an example of what
I want to talk about that clear and convincing underneath reasonable doubt. Like that civil. So in a car wreck or something like that, civil court, you have preponderance of the evidence. That's like for somebody to get money in a case. Well, for somebody to take your kids away from you, that's a level up. That's what's called clear and convincing evidence. Who here has kids? Raise your cards up. So juror number 11. How many kids do you have? 2. You have 2 kids. How old are they? 30. Well, we don't have to worry about that. Who has little kids? Okay, number 9. How old are your kids?
3 and 9.
3 and 9. Boys, girls?
Boys, 2 boys.
2 boys. I also have 2 boys, but my boys are also one almost 30 and one 20 something. So let me ask you this. What if, well, I mean, I'm going to assume you love your kids, right?
Yes.
They're probably very important to you. What would you do, hypothetically? What sort of proof would it take for somebody to convince you that, give me, like, do you mind sharing just the first name of one of your kids?
Dave.
Okay, so let's say Dave. And how old is Dave?
3.
Dave is 3. So let's say somebody was going to convince you that Dave actually had been switched at birth at the hospital with another baby, and that Dave is not your child. And that and let's say that CPS was coming to remove your child from your home. So what level of evidence would convince you that Dave's not your child?
DNA.
DNA, right? So how many tests is one test okay for you?
Yes.
So one DNA test and Dave is out. Bye, Dave. Goodbye. You were sweet, but DNA would be enough for you.
Yes. Yes.
Okay. Do you think that DNA evidence, sometimes people make mistakes?
Yes. I was assuming that the DNA was proper, like everything, the sample, the process is followed.
Okay. So you would assume that whatever evidence is presented, you wouldn't question it. In the case of Dave.
It's tough. My son has blonde hair. So.
I may have a card for you to. I mean, it's a kind of a silly example, but does everybody see what I'm getting at? Think about your kids, or what, like that level of what you would need to have clear and convincing evidence for somebody to take your child away. And I can't tell you what reasonable doubt is, but it's more than that. And if you think of that, like, you know, I'm almost 60. My kids are, you know, grown. They're in their, one's almost 30. And I can still remember how my kids smelled when they were babies. You know, it's that kind of gut punch when you think about something so important to you like that being taken away. And this is even more important than that. And you don't have to get up to the top. You got to get over it. Can everybody hold the state to that high burden? And you can't lower it because it's a murder case. And listen, it's terrible
when people are killed. It's awful. And we are not here to say that people, again, I absolutely understand and believe everybody matters. But we're not here to say that if you find someone not guilty, you're not saying that somebody mattered more than somebody else. And you have to be able to understand that to sit on this jury. Who here thinks that wrongful convictions never happen? Who here thinks that wrongful convictions do happen? Okay. And in this day and age, thank goodness that we see this many cards being raised, because there was a time when people used to not believe that. What do you think happens, juror number 4? What do you think, I say juror, potential juror number 4. What do you think happens if somebody gets wrongfully convicted? Do you think that they can ever go back and fix it?
No, you can't unring a bell.
You can't unring a bell. And what do you mean by that?
Their life was forever changed.
Yeah.
And people will judge even with proof.
You will never get back. You will never get back to that place that you were before people walked in a room and said, I wonder what he did. You never get back to before that time. People will always judge you. And there's been people who have gone to prison for decades. There have been people who died in prison. And we absolutely don't want anything like that happening. I want to know, and this is just sort of a show of hands, who here considers themselves to be a detail-oriented person rather than a big picture person? Juror number 8. Why do you consider yourself to be more of a detail person?
I have a tendency to line up things, get it straight, check it again, and try to keep that going.
Right.
Be.
Have you always been that way? Is it like a personality thing, do you think?
I think it became from early on jobs that you just have to be, you have to really follow through with everything you're going to do to be productive.
Right. And anybody here, I consider myself to be kind of a big picture person. I've learned over time to be more detail oriented, but is there anybody here who, generally speaking, and I know like there's a lot of overlap, but generally speaking, is there anybody here who believes themselves to be more of a big picture type person? And juror number 10.
I am, and I have to surround myself with detailed people.
Right. So I think that and I think that raises a very good point, is that you don't have to be a detail-oriented person to get it right, and you don't have to be a big picture person to get it right, but it's sort of the interplay of those. And I do believe that we usually end up with a pretty good mix of both on our juries, but that's something that can be very, very important. Judge, can you let me know how much time I've got?
20 minutes and 28 seconds.
Okay, let's see, potential juror number 8, 9, 10, 11, 12. Let me ask you, what does this mean to you? Hurt people hurt people.
That's cycle.
What does it mean?
It's a cycle that keeps occurring.
Cycle that keeps occurring, like explain more. What do you mean?
If somebody endured some pain, they're likely to go ahead and cause that pain onto another.
Okay. And let me ask juror number 13. Did you grow up in a perfect family?
No.
Do you?
I don't think there are perfect.
that was my next question. There are no such thing as perfect families, right? Do you think that the type of environment and circumstances that people grow up in affect them and the decisions they make or the things that they do later in life? And how so?
I think if, say you had a father who didn't always follow, like, not the letter of the law, but maybe he worked for a company where he could easily, take money from it somehow, bragged about it at home, made it seem okay, so that it'd be okay for you to do it, the children.
Sure. So, would you agree with that? Is it juror number 14?
14.
Would you agree that sometimes, kids, when they grow up, like they tend to kind of model some of the behavior that they see in their own families?
Sure. Like if your parents were alcoholics, they tend to drink as they get older.
Yeah. Let me ask juror number 16, 15, sorry. Have you ever had anybody in your family, or have you ever known anybody that dealt with somebody that was kind of a bully in their family? Yes. And you don't have to overshare like lots of details, but tell me a little bit about that situation or what you know. How did that impact the family?
It can impact the entire environment. And when someone's being picked on or mistreated, I think it's an overflow effect and everyone feels it.
Okay. Number 16. Have you ever known of cases where maybe there were, say, like siblings, where one would kind of pick on another one? Do you think that's common or uncommon?
Common.
And why do you think that to be common?
Because you're always around the other person, and it's very common for siblings to bicker. And then one might be more successful or better off or better educationally or whatever reason.
Yeah. Who here grew up with siblings? I'm what my grandmother used to refer to as an Irish twin. My brother and I are about a year apart. So who here grew up with a sibling kind of close in age to them? Okay, keep your cards up. Now, keep your cards up. Now take your card down if you never had a fight with your sibling. Okay. Now, of those of you who had, go ahead and put them down. Of those of you who ever had a sibling who fought, juror number 17, do you think there's a difference between siblings fighting and one sibling bullying another?
Yes.
And what's the difference there? What's the difference to you?
Fighting is like, they're just like.
Oh, I'm sorry, just 1 second. Excuse me. Kathy, if you could move over so the court reporter can see and hear.
Sure.
Fighting between siblings is just like playing. I'll put it like that. But bullying to me is like if one is constantly being really ugly to the other one.
And when somebody gets bullied over a long period of time or things go on like that, what are some of the impacts that can have on a person, do you think? Juror 18.
Can you ask the question again? I'm sorry.
Sure. If somebody's getting bullied over a long period of time, like what sorts of impacts can that, or how would that affect someone? Do you think that you would be able to see changes in their behavior from getting picked on or terrorized over time?
They probably withdraw within themselves.
Okay. Juror number 19, can you think of ways that that might impact someone?
Fear, anger.
Fear and anger? And, who here has been picked on or bullied when you were kids? A lot of us, right? Who has been picked on like as a teenager? So number 26, let me ask you, you look like a teenager still. So how does that make you feel, or how does that sort of occurrence, I guess, make you feel, or how did it make you feel?
I guess it did make me feel some sort of sadness within myself. I really see it because me as a type of person, I think it's very common.
I'm sorry, sir, I need you to speak up.
Oh,
And you have a deep voice, and you probably gotta be louder.
so it depends, I guess, on the person. In my personal opinion, because I'm very laid back and I'm very chill with it. It didn't really it made me upset, but I've always been able to like talk to myself in a sense, or like not rely on other people, be able to like necessarily care. So I guess it's not really much.
Okay. Is there a difference to you, say, between like verbal bullying and physical bullying?
There's definitely a difference between verbal and physical. They could go hand in hand, and they could lead to, or they could lead to a cause of something similar, let's say an effect, right? But there is a difference, and usually one would outweighs more than the other.
Okay. And so that brings me kind of back around to the whole self-defense concept. And the judge is going to give you the law. You'll get what's called a charge of the court if you're on the jury at the end of all the evidence presented to you. And so please don't feel like you have to read all these. There's not going to be a test afterwards, I promise. But these are just the concepts that will be in the charge. Some of them we anticipate, and we want to just make sure that you can follow the law, because that's also part of what you have to do. If you're on the jury, you have to follow the law, whether you agree with it or not. You have to follow it. So self-defense, the law provides that you can defend yourself. Is there anybody that has a problem with that? That you have a right in this state, and in most states, you have a right in Texas to defend yourself and to use force that is reasonable. Now, remember when Anna was showing you, you can bring a fist to a fist fight. You can bring a gun to a gun fight. Well, and then you can but you can't bring a gun to a fist fight. And that's actually not quite the law, because the law does provide that you can exhibit a deadly weapon if someone is threatening you with not deadly force, but force. So let's just say if you're,
Yes.
when we're talking about self-defense, you can protect yourself against force, or an assault. Say we're talking about fist fight. If I'm gonna punch you, or number 5, if I'm gonna punch you and I'm coming where I'm saying I'm gonna knock your teeth out, anything like that. If I'm doing that, section 904 says the threat of force is justified when the use of force is justified by this chapter. And you go up above. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor's purpose is limited in creating an apprehension that he will use deadly force if necessary, does not constitute the use of deadly force. And so what that means is that if I go somewhere and somebody's threatening me with a fist fight, I can pull a gun. Now I can't shoot them, right? But I can pull a gun, I can pull a knife out, and I can say,
10
get away,
minutes.
leave me alone. That's the law. Is there anyone here who has a problem following the law to where you don't think that you could be a fair juror on a case that may involve you applying that law? Is there anybody here who just has a problem with that? Number 22, 30, 37, and 26. Okay. And when we say your numbers, it may be that we want to talk to you a little bit further up at the bench later. So let's talk about that self-defense. Do you think juror number, what's your number? 29. Juror number 29. Do you think that the self-defense laws require that you have to wait until somebody physically hits you before you can say, bring out your gun to say, leave me alone?
Yes.
You think somebody has to hit you first?
Yes.
Okay, that's actually not the law. The law does not require for somebody to physically assault you for you to be able to pull out a deadly weapon to threaten somebody. Does everybody understand that concept? Because that's the law. Okay. Let's say if I pull out a gun, do you have to wait for me to shoot you before you shoot me?
No.
Okay. Let's say juror number 22. If I come at you with a knife, do you have to wait until I stab you to be able to shoot me? The judge is going to be so happy with you.
Thank you. You have saved the panel.
Can you repeat the question?
If I come at you with a knife, do you have to wait until I stab you to be able to shoot me?
Shoot you?
Mm-hmm.
Yeah.
Okay. Do you have to can I just nick you, or
I mean, if you're just showing it to me, I don't feel like I can shoot you.
if I'm coming toward you with a knife, or I'm like this, I mean, wouldn't that be a sign to you that I'm about to use deadly force to you? Okay. Who here thinks you would have to wait to get stabbed to defend yourself? Number 37. Not correct. Sorry, but I just want to make sure everybody understands the law. You do not have to wait. You don't have to get shot to be able to shoot someone to protect yourself. You don't have to get stabbed to be able to stab someone else to protect yourself. Does everybody understand that? Okay. Is there anybody here who feels like they can't follow the law? Size? Does size matter? Just asking. Juror number let's see, are you 20, juror number 27? How do you think that size, age, factors like that, how do you think that those play into self-defense issues? It doesn't? So if this guy next to you, can you stand up, both of you? So if this guy next to you, you don't think that there's that somebody's size or their age or anything comes into play?
To play to defend
First,
myself or?
well, I mean, if you're thinking about in a
5 minutes,
I'm sorry?
5 minutes.
Thank you. If you're thinking about with regard to self-defense, or let's say me and him, who do you think's gonna win in a fight between me and him?
Nowadays, you.
I'm pretty.
Everybody goes karate and stuff, you know? Never know.
I don't know how you know this, but when I was a kid, I had a very bad temper, and I was the kind of kid that I would take an ass beaten, pardon my language, that's what we used to call it back in the day, just to get my licks in with somebody. So I was a mean kid. But now, no, I can't, I'm too old and I'm too little. I can't win any fights. But you can go ahead and sit down. But you know, things like age, size, things like those matter when you say and who's fearful and who's not, who's been bullied, who hasn't, all of those things. I had all these great questions, but here's what I want you to know. You're going to get the law from the judge. We don't know what the facts in this case are going to be. We know what the charge is. At the end of the trial, the judge will decide what those facts have raised as far as legal issues and what you as a jury will decide. And you will have lots of questions and lots of instructions. So you will go through those. But here's the thing. The defense is raised. We have to raise that defense, and then it is up to the state to prove beyond a reasonable doubt that it was not self-defense. So the burden never shifts. We never have to prove anything. They have to prove it, and they have to disprove it. And that doesn't mean that they get any extra benefit because, oh, their job's harder or not. Imagine how important this is to everyone. So here's what you have to do if you're a juror. You just have to follow the law, and you have to look at the evidence and consider only the evidence. That's it. You have to hold the state to their burden. You have to bring your common sense and reason to the jury room. And here's the most important thing. You have to be able to have your own decision and to stand by that decision. You can't let other people make your choice for you. You have to have the case proved to you beyond a reasonable doubt. Anna already said this, but I want to make sure if there is anyone here who feels like after listening to all of us that you just cannot be a fair and impartial juror for this kind of case, maybe a theft case or something else you'd be great for, but for whatever reason, this is just not a case where you feel like you could do it justice and give it the fairness it deserves, you've got to let us know. So if we don't already have your number, if you haven't already raised it, if there's anybody here who still needs to approach the court, would you please raise your cards? I see number 6, number 8, number 9, infinity, number 9, 11, number 26, 30, 31, number 37, number 46, and anybody over here? Okay. Thank you so much for being so patient with us, and I look forward to trying the case with the 12 of you who end up on our jury. Thank you.
All right, so ladies and gentlemen, this is my instruction to you, and we can go off the record. Leave your numbers in the seats. Please take your personal items with you. I'm going to have you step outside in the hallway. Some of you all may be called back in case either side has more questions for you. Please do not wander off too far. And I'm going to put us being back here at, we'll play it by ear and say 4:45. So if y'all will please just make sure you're outside in the hallway by 4:45. All right, everyone, please rise for the jurors.
Yeah, down.